Hello everyone, we are from Group 2 and we would like to present today about case analysis on law of agency. For that, I would like to introduce the group members. They are Nurul Kharisa, Anusri Murthy, Damayanti Anaprabhan R. Murgiswaran, Nur Aima Fatma, Sharifa Nuraliza and Nur Filzatul Husna.
According to in pari delector, the constructed dismantling the doctrine that protect the lawyer from malpractice liability. What I learned from the cases, don't ever have to make a decision without discussing or doing direct research like how court did to the plaintiff in the cases. Second point, when making a decision without a check motion will result in various suspicions. My recommendation, according to clause 24, both participants should agree and be sensitive to the issue of many things in contract. I suggest that this section be further strengthened through emphasis and implementation. All agents involved in an agency should be on duty to follow the scope of work more transparently, and if they fail, appropriate punishment can be imposed, such as suspension.
The case I picked for the authorities of agent is Tan Kiang Ong vs. Andrea S. H. Chong 1974. The lessons learned from this case is the principal may sue the agent and the third party for damages he may suffer. Secret profit means that the commission is received without knowledge of principal when an agent is found to be making a secret profit. Section 169 states that the principal can recover the buy from the agent. Recommendation for the case is Supreme Court that finds that principle of equity should apply and the secret commission is held on the trust for the principal, which entitled the principal to a proprietary claim against the agent. Section 168 and Section 169 of Contract Acts 1950 should be enforced because any distinction between of the secret payment was made was artificial.
Hi all, I'm Anusri Murthy. The case that I have chosen is Malaysian vs. Malaysian government. In this case, Malaysian vs. Malaysian Government Cooperative Housing Society. Malaysian was the director of the housing society. He negotiated with the third-party Manicum for the purchase of land. A quarter of this profit was passed to Malaysian as a bribe. From this case, I have learned that once an agent receives a secret profit, the law presumes that the payment has had him to the detriment of his principal. Law prohibited bribery can be used to be punished the agent and also the third party who offered the bribe. Further, not to disclose any confidential information or document entrusted to the agent by his principal. It is important to be loyal and trusty to the company. In my perspective, penalizing under this section 168 and 169 is a good judgment. However, I think that someone who is involved in such cases must be blacklisted as the behavior of dishonesty and have lost credibility. Further, the reclaimed amount can be increased and it could be a lesson to every individual. The enforcement of law in this case must be implemented that the bribery and corruption cases must be reduced in Malaysia.
So the cases of authorities of law agency that I picked is between Liu Yuanyin and also the Great Eastern Life Assurance in 2011. So what I learned based on these cases is about the forging the documents that relate to the section 463 under penal code. So recommendation that I would like to suggest is the defendant should investigate more about these cases before accusing the plaintiff forging the document because of the MAD, which is the third party already give the permission to the plaintiff to sign for his behalf.
Authorities of agent is between Won Munwai vs. Won Tampa and Anwar Onen 1986. The things that I learned from this case is trustworthy in the family. It shows that the first defender was taken advantage by the power of attorney given by his own elder brother, the plaintiff. Besides that, the first defendant is failed in doing his duty as agent of the plaintiff by selling the said land without inform to the plaintiff. The recommendation that should purpose is wrote the will to divide the property. The will is made to prevent the argument between families or people that is related. However, the contract is a must when dealing the lawful processes of authorization. For example, if the person A is having difficulties in handling the said property, person A need to give his authorities to the person B who can be trusted to. There must be awareness to prevent any misleading or mistakes.
I took away from the case Keppel v. Wheeler that communication is key to preventing future issues. Instead of communicating with their principal, they went to the original offerer suggesting he could sell on and make a profit. In my opinion, according to Section 167 under Contract Acts 1950, the agent must communicate with the principal. The defendant must always behave in the best interest of his principal and must avoid letting his own interest collide with that of his agent.
Based on American International Assurance Company Ltd versus Ho Hien V, what I learned from the cases, the judiciary prefer the plaintiff side because it is more concerned with bodily justice, thinking about other fields such as business midwife. This invites the court to pay more attention to the law by agreeing to reopen these termination cases. Second point, power does not symbolize anything, and deceit cannot escape us from trouble. The action of a lawyer who tells a client, "Come agent of the company to lie and avoid bankruptcy." My recommendation, according to section 541, which is only for bankruptcy cases, there should be more mention about how the estate, actually including trustees and receivers, were included. This can be held like before a company exists. Second point, any termination must follow the procedure that has been set in accordance with the contract agreement between the two parties, and if not, the offender will be punished either in the form of money or imprisonment.
The case I picked for the termination of agent is Saubregi vs. Oriental Assurance 1946. The lessons learned from this case is agency is a contractual relationship between a principal and an agent. The principal may terminate their agency relationship with one of the three ways. However, reasonable notice must be given to the agent. Termination of agency is under on section 154 until 163 of Contract Act 1950. The right to cancel an agency may also depend upon some stipulation in the contract. The recommendation for this case is therefore section 1591 of the Contract Act of 1950 should be enforced, is necessary for protecting the interests of contracting parties and preventing misunderstanding and disputes by the agent. This set out the elements that limit the ways in which a contract may be entered and carried out. If a contract is breached, the Act sets out how the said contract can be enforced in the court of law.
J.K. Sayani vs. Bright Brothers is the second case that I have chosen. The case law discusses the aspect of termination of agency and the relationship between parties of an agency and the extent of their right to claim. What I have learned from this case that relationship between the principal and agents forms an agreement between them. The law of agency requires both the parties to notify before any terminations. It is important to make a clear contract to both the parties understand each other well. Based on the case study, the judgment was made correct and accurate. However, I could recommend that the compensation of respondents should be increased under section 158, where the 6-month compensation could be given rather than 4 months compensation. I think it will be benefit for the respondent to recover back their losses.
Okay, the cases of termination to contract of law agency that I picked is between Yon Swee Chon versus Uni Asia Life Insurance Berhad that happened in 2010. So what I learned in these cases is about the terminations of the contract by the defendants that relate to the section 158 under the Contract Act 1950. So recommendations, I would like to suggest to the plaintiff to communicate with the defendant regarding to any matters that happen in the contract of law agency. Before that, we should relate to the sections of 167 under the Contract Act 1950 before issues the matter into the court.
Of termination of agent is between Network Pet Products M Senior Berhad versus Royal Canin SAS and Royal Canin Malaysia Senior Berhad on year 2013. I learned that the health of contract, whether it is by orally or written, is important when doing a partnership with other parties. There are no formal renewals from 2008-2011 until the notice of termination letter of commercial relationship was given by RCSA to NPP on October 2011. The formal contracts are important when doing a business with other parties to prevent any accusation or mislead in managing business together. The recommendation for the case is the attribution of the legal contract when doing any commercial relationship with other parties. It is also need to be applied when the partnership wants to terminate the commercial relationship. A legal contract must be entered into the formal or informal meeting to prevent any misleading information from each other parties.
What I learned from the case through Vinan is that a principal supervening mental incapacity has the effect of terminating the agent's actual authority, regardless of whether it was granted by deed or not, or whether it was stated to be irrevocable or not. Bramwell LJ voiced his opinion that the only thing that counts as effort is insanity. I believe that the principal must represent to the third party that the agent is his agent. The representation had to have been relied upon and used by the third party. Additionally, the representation that caused the third party harm must have prompted him to change his stand.